Welcome to Introduction to Criminal Litigation. This lesson has 4 parts. An overview of criminal litigation is part 1. Sources of the law and rules guiding Nigerian criminal litigation is part 2. Types of criminal courts is part 3. Key concepts to bear in mind is part 4. We hope that you enjoy this class. Slide 2 contains a high-level overview of what we are going to be considering. Part 1 is Introduction or an overview of criminal litigation, and Part 2 is Sources of the law or rules guiding Nigerian criminal litigation. This slide shows us Part 3, Types of Courts, and Part 4, Key Concepts to bear in mind. Let's take a look at the first part. An overview of criminal litigation. What is criminal litigation all about? To answer that question, we will attempt to define the term criminal litigation and the opposite term civil litigation. This will be followed by comparing and contrasting the two. Let's dive right in. What criminal litigation is all about. Criminal litigation is the procedural law governing court trials of accused persons, that is, criminal trials. Criminal law is a substantive law that defines crimes and punishments. Criminal litigation is the set of procedures for making, administering, and enforcing criminal law. Criminal litigation comprises the rules by which our courts hear and determine what happens in criminal proceedings, and this would include how the rules of evidence apply in trials of an accused person or accused persons. Civil litigation, on the other hand, is the procedural law governing court trials of persons who may have failed in their duties or rights or obligations towards another, that is, civil trials. Civil law is thus the substantive law that defines rights and responsibilities, while civil litigation is the set of processes for making, administering, and enforcing civil law. By the way, in common law legal systems such as Nigeria, all non-criminal law is civil law. Civil litigation therefore comprises the rules by which our courts hear and determine what happens in civil proceedings, where the rights, duties, and obligations of persons, be they natural or legal, amongst themselves, is alleged to have been trampled upon, denied, or breached, and should the court establish the same, the court may award the injured party compensation for the injury so established. Anyone can institute a civil suit. However, only a public official, known as a prosecutor, can institute a criminal trial against an individual alleged to have committed a crime or crimes. In doing so, the prosecutor is a representative of the government. It is the duty of the prosecutor to attempt to establish that the accused committed the alleged offense beyond all reasonable doubt, unlike in civil cases where the plaintiff needs a preponderance of evidence, that is, that on a balance of probabilities, the position of the plaintiff is more likely to be the true version of events than that of the defendant. In summary then, criminal litigation involves prosecution by the state or federal government of a defendant charged with a crime while civil litigation involves matters between individuals, be they natural or legal, against each other for matters such as torts, contract disputes, fundamental human rights violations, to mention but a few. Criminal litigation is driven by the idea of punishment, while civil litigation is driven by the idea of correcting a wrong and of compensating the claimant for his loss. Let's go on to the scope of the criminal litigation course. This is just a highlight, not a deep dive. The range of issues that criminal litigation addresses, or this criminal litigation course addresses, include how to lay a complaint before a law enforcement agent such as the police, a police officer, how law enforcement should investigate a criminal complaint, how law enforcement should conduct searches of suspects, how law enforcement should conduct arrests of suspects, including who can arrest suspects, how law enforcement should interview a suspect, how law enforcement should institute criminal proceedings, how law enforcement should draft charges, conditions for granting bail to suspects pending trial, the constitutional safeguards to ensure fair trial of a defendant, how a criminal court should convict and sentence a defendant, how judges should deliver judgments, how convicted criminals can appeal verdicts that they consider unjust. Now that we are done building a bird's eye view of our criminal litigation course, let's do a deep dive by going through the entire curriculum. The first part of the course is entitled Introduction to Criminal Litigation, and we will treat an overview of the criminal litigation course, sources of the law and rules guiding criminal proceedings, types, sittings and settings of criminal courts. In part, we will treat jurisdiction and venue of courts of criminal jurisdiction. We will take jurisdiction separately and venue separately. We will apply these concepts to Nigerian courts, and we also apply it to the International Criminal Court. However, we will be concerned mainly with the jurisdiction of the International Criminal Court. We will address searches, arrests, and constitutional rights. And we will travel down such topics like authority for searches and arrests, execution of searches and arrests, admissibility of materials, procedure for challenging searches and arrests, constitutional safeguards relating to these procedures. Then, we will treat pre-trial investigation and police interviews, how police stations should conduct interviews, statement forms to be filled at the police station, and police bail, legal representation, and the rights of suspects at police stations. Issues in police investigation and admissibility such as alibi, confession, judges' rules, identity of suspects, expert opinion, and handling of exhibits. In part 5, we will deal with the institution of criminal proceedings. We'll consider authorities that can initiate the institution of criminal proceedings, such as the Attorney General, the DPP, other officers, the police, other prosecuting authorities such as customs, ICPC, EFCC, SSS or TSS, as well as private persons. We'll consider the mode and scope of institution of criminal proceedings by looking at information, charge, and complaints. In part 6, we will take a look at charges, the forms, the contents, the rules of drafting charges, amendment of charges, procedure after amendment, sample charges, and there will be a practical exercise involving the drafting of charges. You'll look at bail pending trial, the types, the scope, the consequences of bail, the procedure for application, and there'll be a practical exercise involving the drafting of motions, summons, and affidavits. In part 8, you will pay attention to constitutional safeguards to ensure fair trial of an accused person. We will treat such rights as the right to counsel, the right to silence, access to defendant in custody, information of the crime alleged to have been committed, the provision of an interpreter, fair hearing versus the presumption of innocence, that offenses must be known to the law, the rule against double jeopardy, the right to examine witness called by the prosecution, right against trial upon retroactive legislation, right against trial for an offense for which the accused has already been pardoned. We will also take a look at trial. In fact, trial is such a major part of this course that it is broken into 4 parts. The first part is attendance of parties and arraignment. We will treat the presence of the accused, complainant, witnesses, and counsel in court, processes to compel the attendance of the accused, summons, arrests, and warrants, dispensing with the presence of the accused, as well as the presence of the complainant. We'll also take a look at the duties and roles of the registrar, counsel, and the judge in criminal trials, arraignment, recording of plea, options open to an accused upon arraignment. Trial. We will take a look at trial preparation, the rules of evidence as to burden and standard of proof, competence and complainability of witnesses, how to develop a case theory or trial plan, subpoenas and witness summons, types, issues, and the use, how to prepare witnesses for trial, opening address, and delivery. Entitled Examination of Witnesses, we'll take a look at what is examination in chief, what is cross-examination, what is re-examination, what purpose do examinations serve in a trial, what questions are not allowed in examination in chief, admissibility of documentary evidence such as confessional statements, expert evidence, and police reports, admissibility of PSA evidence, the procedure for refreshing memory, and the procedure for dealing with hostile witnesses. Part of trial, that's part 4, presentation of the case for the defense. We will treat options available to an accused person at the close of the case for the prosecution, no case submission and when it is made, resting case on the prosecution's case, opening address for the defense, procedure for visit to a locus inco, application of the ex improviso rule, final addresses for the parties. In part 13, we will treat judgment and sentencing. The contents, the type, the form, and the delivery of judgments, the effect of failure to comply with Section 308 of the Administration of Criminal Justice Act, time limit to deliver judgment, the effect of failure to deliver within the time set by the Constitution. Conviction, allocators, its desirability and perspectives. Sentence, the power of a court to take other offenses into consideration. Types of punishment, the death sentence, the form of pronouncing death sentence, the effect of failure to comply with the form, exceptions to death sentence, the prerogative of mercy, and restorative justice. Under the heading Appeals, we will consider the right of appeal, who can appeal, where to file appeals, time limit for appeals, type of appeal, constitution of the court to hear appeal, difference between appeal and case stated, appeal from magistrate courts to high courts, the time limit to file notice, the grounds upon which the prosecution may appeal, and the grounds upon which the accused may. We'll also look at bail pending review, the power of judicial review, appeal from High Court to the Court of Appeal, using subtopics such as when the appeal may lie as of right and when the appeal may lie with leave, notice, compilation of records, filing of briefs of arguments, hearing, orders that the court can make after hearing, appeal from the Court of Appeal to the Supreme Court, using such subtopics as when appeal may lie as of right, when appeal may lie with leave, notice, compilation of records, filing of briefs of argument, hearing, orders that the court can make after, security to prosecute appeal, abatement of appeal, abandonment of appeal, effect of wrongful admission or rejection of evidence, mistrial or miscarriage of justice, circumstances under which a trial will be ordered by an appellate court. Having concluded part 1, let's now take on part 2, sources of the law and rules guiding Nigerian criminal litigation. We will cover a total of 4 subtopics: an overview of the sources, what laws and rules of trade in various parts of Nigeria, what laws and rules applicable in various courts in Nigeria, and finally, there will be a take-home assignment involving comparative comparison the laws and rules of trade in various courts in Nigeria. Let's take up the first part, an overview of the 3 types of sources. The rules or laws applicable depend on the following factors. The first factor is the type of court. Is it a magistrate court? Is it a state court? Is it a federal high court? Is it a court of appeal? Or is it Supreme? The second factor is whether or not the state has investigated the ACJL, as short for Administrative of Criminal Justice Act, and if it has not, then whether the state is in northern Nigeria or southern Nigeria. The third factor is whether or not an appeal exists in the law applicable to a particular jurisdiction and the express provisions of the law in such circumstances. With that at the back of your mind, let's now take a look at the sources, the high level overview of the three sources that you will be considering. You can see them shown on the screen: principal sources, secondary sources, as well as tertiary sources. Let's take the first principal source, the ACJL. ACJL is short for Administration and Criminal Justice Act 2022. Before the ACJL came into force, the major procedural criminal law in Nigeria included either the Criminal Procedure Act (CPCL) or the Criminal Procedure Code (CPCL). Legislation enforced in Nigeria determines whether Nigerians speak along Nigeria's northern or southern region. For northern Nigerian states, the CPCL carries sway. For southern Nigerian states, the CPCL reigns. Since 2015, the principal statute applicable to the High Court of the all other federal courts, and any state high court that tries a federal offense is the ACJL. Please refer to section 2, subsection 1 of the ACJL. The next principal source is the Administration of Criminal Justice Law, ACJL. If a state domesticates the ACJL, it becomes known as the ACJL. A total of 24 states out of Nigeria's 36 states are down this. They include Anambra State, Cross River State, Delta State, Ekiti State, Enugu State, Kogi, Lagos State, Ondo State, Oyo State, Kaduna, Rivers State, Akwa Ibom State, Edo State, Ogun State, Plateau State, Osun State, Kwara State, Adamawa State, Bayelsa State, Kano State, Jigawa State, Abia State, Benue State, and Nasarawa State. Our third source is the Criminal Procedural Code law. The history of the Criminal Procedural Code in Northern Nigeria can be traced in the then Chief Justice of Nigeria, H.C. Boland's Criminal Procedure Proclamation, 1903. It was based on the Gold Coast Criminal Procedure Ordinance of 1876. Following the amalgamation of Northern and Southern Nigeria, Governor General Washington sought to unify the criminal procedure laws of both regions through a consolidated ordinance known as the Nigerian Criminal Procedure Ordinance of 1940. So for a period of time, all of Nigeria had one criminal procedure law. And subsequently, the Criminal Procedure Code was passed into law by the Northern Regional Government in 1960. Northern states later domesticated it and we have CPCL, which is short for Criminal Procedure Code, as a statement. This has the effect of making the CPCL the principal criminal procedural law applicable in those territories until the ACJL was domesticated to become the ACJL in those states. States which still use the CPCL in good vouchers, this is actually attempting to domesticate the ACJL at this moment. Sokoto, Kebbi, Niger State, Zamfara State, Katsina State, Yobe State, Borno State, Gombe State, and Taraba State. Criminal Procedure. The history of the criminal procedure law in southern Nigeria is traced back to the Gold Coast Criminal Procedure Ordinance of 2006, which was originally enacted in Lagos as part of the colony of Gold Coast. Following the amalgamation of northern and southern Nigeria, the Ordinance of Abuja sought to encourage criminal procedure laws of both regions through a consolidated ordinance under the Nigerian Criminal Procedure Ordinance of 2014. This law was subsequently revised, and this led to the passage of the Criminal Procedure Act of 1945 that applied all of Nigeria. However, due to its incompatibility with the mode life and region of northern Nigeria, in 1967, its scope of application was restricted to southern Nigeria. Southern Nigerian states then domesticated that it became the CPL, that's at the state level, instead of the CPA, which applies at the federal level. By virtue of the now repealed Section 3 of Federal High Court Act, the CPA used to apply the proceedings of the Federal High Court and made it of Magistrates. The C Section 493 of the ACJL which repealed the CPA, making the ACJL current procedural criminal legislation in force of the Federal High Court and indeed all federal courts. That brings us to the end of principal sources of criminal law and criminal legislation. Our first secondary source is the 1999. The reason why it's called the secondary source is that these are sources that, although they may contain some provisions on criminal litigation, that is not their own or sole purpose. Let's take on the 1999 Constitution of Nigeria as a number. It feels rather strange that the Constitution either with one law or rule that said that the foundation of the legal system can be called the secondary source of law. Notwithstanding, the Constitution has a number of provisions that deal with criminal litigation, including but not limited to the supremacy clause found in Section 1, Subsection 1 and 3, the right to life in time in Section 3, the right to personal liberty, Section 55, the right to fair hearing, Section 6, knowledge of appeal, Section 174, Subsection 1, Section 2 and 11, Subsection 1, the prerogative of mercy, Section 175, Subsection 1, and 212, Subsection 1, as well as the jurisdiction of criminal courts. Our next source is Criminal Code Act of Criminal Procedure. The Criminal Code Act and its state level equivalent, known as the Criminal Code Laws of the respective states, as the case may be, constitutes southern Nigeria's substantive criminal law. defines crimes and basically criminalizes offenses considered to be improper conduct. Thousand years. Our next secondary source is the Penal Code Act of Penal Code Laws. This is Northern Nigeria's equivalent of the Criminal Code Act. According to the book, the Penal Code of Northern Nigeria and the Sudan by led here, so not a book, an article. The Penal Code Act in use in Northern Nigeria was enacted in 1959, but it came into effect in 1960. It was based on the Penal Code of the Sudan, enacted in 1890, which in turn was based on the Indian Penal Code drafted by Lord Macaulay between 1833 and 1857, and brought into force in 1860. Until then, substantive criminal law in Northern Nigeria was based on the Nigerian Criminal Code of 1960, promulgated by Lord Macaulay following the amalgamation. The Penal Code Act criminalizes offenses considered to be improper conduct in Northern Nigeria. Our next secondary source is the Evidence Act. The law of evidence is relevant to criminal litigation because it governs how both sides will divide the prosecution and the defense to prove the facts they intend to rely on in the course of the criminal proceedings. It deals with the quantity, quality, and even the type of proof necessary to establish one's version of events in court. With respect to criminal litigation, the standard of evidence required of the prosecution is evident beyond all reasonable doubt, unlike in civil litigation where the standard of evidence required of the claimant to succeed, which is a preponderance of evidence. Our next type of is known as secondary acts, secondary enactments. These include the Police Act, the Armed Forces Disciplinary Proceedings Special Provisions Act, Coroner's Act and Coroner's Laws of the respective states, Children and Young Persons Act and laws of the respective states, Supreme Court Act and Supreme Court rules, Court of Appeal Act and Court of Appeal rules, Federal High Court Act and Federal High Court rules, High Court laws as well as Magistrate Court laws. The list continues to include the Independent Corrupt Practices and Other Related Offences Act, the Bank Fraud and Other Fraud Related Offences Act, the Donor Check Offences Act, the Recovery of Public Property Special Provisions Act, Firearms Act, Robbery and Firearms Special Provisions Act, Public Order Act, Terrorism Prevention Act, Money Laundering Prohibition Act, as well as the Money Laundering Prohibition Amendment Act, Cyber Crimes Prohibition and Prevention Acts. With that, we have concluded with the secondary sources. We now move on to tertiary source. What do you mean by tertiary source? English, procedure, and practice. With Nigerian criminal procedure laws failed to make provision for the procedure for handling a certain type of criminal matter, or if Nigerian criminal procedure laws make provision for the procedure for handling a certain type of criminal matter, they fail to state the conditions for applying such provisions, then, in the first scenario, if the jurisdiction is the southern Nigerian state, that has not been instituted with ACJL, then section 363 of the CPL shall apply in each state that the procedure and practice for the time being involved in the High Court of Justice in England in criminal trial shall apply to trials in the High Court insofar as this Act has not specifically made provision thereof. Scenario 2. If the jurisdiction is Lagos, then section 266 of the ACJL applies to each state that the court shall adopt such procedure as will in its view do substantial justice between the parties. Scenario 3. If the jurisdiction is the FCT of Federal Courts, wherever situated, then section 492 section 2 of ACJL applies to each case. Where there are no express provisions in this Act, the court will apply any procedure that will meet the justice of the case. Scenario number 4. If the jurisdiction is a northern Nigerian state that has not been instituted with ACJL, then the CPCL applies in section 35 of the High Court Law of Northern Nigeria in the case. And the reception of and reliance on any rules of practice and procedure is expressly forbidden. In practice, Northern courts will do what determines what constitutes substantial justice to the parties involved. There's a case related to this, as charges in this case, the 1981 case, where it held that a bail application in the High Court, in the absence of particular directions, was by summons or by motion. Like in the South, where a bail application is by summons. So, an alternative classification scheme is hereby proposed. In this classification scheme, there are basically two types of law. There is substantive law and there is procedural law. Substantive criminal law defines crimes and punishments. Procedural criminal law is the set of procedures for making criminal law via proceedings, administering criminal law as codified in statutes, as well as enforcing criminal law. To better understand this classification scheme, let's study the history of criminal legislation in Nigeria. Basically, the English handed over to Nigeria two kinds of criminal legislation: substantive criminal legislation and procedural criminal legislation. Let's take a look at the substantive criminal legislation first. First of all, we have the Criminal Code of Northern Nigeria of 1904 for the North. Unfortunately, there was no equivalent for the South. Not until following amalgamation, when Lord Lugard passed into law the Nigerian Criminal Code of 1916 for all of Nigeria, that's both the Northern Nigeria and Southern Nigeria. Following independence, we then have the Northern Nigerian Penal Code of 1960, or the Penal Code for short, and then Southern Nigeria had the Criminal Code Act. We are now done with substantive criminal legislation. Moving on to the procedural criminal legislation. It all began with the Criminal Procedure Ordinance of 1876, which was enacted in 1903 in the South, and H.C. Golan's Criminal Procedure Proclamation of 1903 in the North. Following the amalgamation, we had a consolidating ordinance known as the Nigerian Criminal Procedure Ordinance of 1914. Subsequently, Northern Nigeria adopted the Criminal Procedure Code, while Southern Nigeria went with the Criminal Procedure Act. Now we have the ACJL for all of Nigeria at the federal level and for the FCT, and the ACJL at the state level for states that have domesticated the federal legislation. However, since not all states have domesticated it, some states still have procedural laws based off, and what I mean by based off is that those laws are reenactments of the CPC or the CPL, depending of course on whether the state is in the north or the state is in the south. You may have observed that we have included the Evidence Act under procedural criminal legislation. And that's because Merriam-Webster's dictionary defines adjectival law as the portion of the law that deals with the rules of procedure governing evidence, pleadings, and practice. According to another legal source which we consulted, adjectival law pertains to and prescribes the practice, the method, the procedure, or legal machinery by which substantive law is enforced or made effective. In short, it prescribes the procedure for obtaining a decision according to substantive law. Modern jurists now prefer to use the term procedural law instead of adjectival law. So that's the relationship between adjectival law and procedural law. Just as adjectives describe or modify nouns or pronouns, adjectival law modifies how substantive law is enforced or made effective. In fact, the role that the Evidence Act plays is trying to create a level playing ground for the prosecution and the defense in the criminal case. So it amends the procedure or affects the procedure. Our third source is English procedural criminal legislation. We already treated this when we treated the other classification type, so whatever we said there applies here with equal force. It's just that this is a different way of looking at the classification of the sources of criminal litigation. Let's take a look at the laws and rules applicable to criminal litigation in the various parts of Nigeria. In northern Nigeria, we have the 1999 Constitution as amended, the Administration of Criminal Justice Law, ACJL, if the ACJL has been domesticated, or the Criminal Procedure Code Law, CPCL, if the ACJA hasn't been domesticated, the procedural rules of the respective courts in the various northern states, the magistrate court laws of the respective northern states, subject matter specific criminal laws, as well as offender type specific criminal laws such as the Children and Young Persons Acts and laws of the respective states. For southern Nigeria, we have the 1999 Constitution as amended, the Administration of Criminal Justice Law if the ACJA has been domesticated, or the Criminal Procedure Law CPL if the ACJA hasn't been domesticated, procedural rules of the respective courts in the various southern states, magistrate court laws of the respective states, subject matter specific criminal laws, and offender type specific criminal laws, such as the children and young persons laws of the respective states. And for all of Nigeria, we have the 1999 Constitution as amended, the Armed Forces Act, the Federal High Court Act and Rules, the Court of Appeal Act and Rules, the Supreme Court Act and Rules, as well as the ACJL. Let's take a look at the laws and rules applicable to criminal litigation in various courts in Nigeria. Federal courts first. In the federal court, we have the 1999 Constitution as amended, the statutes establishing the courts, such as the Federal High Court Act, the Court of Appeal Act, the Supreme Court Acts, etc. You also have the procedural rules guiding the operations of the respective federal courts. For state courts in northern Nigeria, we have the 1999 Constitution as amended, the procedural rules guiding the operations of the respective northern courts, either the ACJL if domesticated, or the CPCL if the ACJL JA has not been domesticated, the magistrate court laws of those states, and finally, for the state courts in southern Nigeria, we have the 1999 Constitution as amended, the procedural rules guiding the operation of the respective southern states, either the ACJL if the state has domesticated the same, or the CPL if the ACJA wasn't domesticated, and then the magistrate court laws of those states. So we now have our take-home assignment, comparing and contrasting the laws and rules applicable to various courts in Nigeria. Basically, there are a minimum of two laws that are applicable to criminal legislation or litigation in the various courts on the screen. The question is, what two laws regulate procedure at the Federal High Court? What two laws regulate procedure at the AFCT High Court? What two laws regulate procedure at the various state high courts? What two laws regulate procedure at magistrate courts? What two laws regulate procedure at a court martial? So that's our take-home assignment. If you have followed the lecture so far, it should not be an impossible task to fulfill. With that, we are done with part 2 of this lecture. Part 3 is entitled Types of Criminal Courts. The first classification scheme lists the courts as the Supreme Court, the Court of Appeal, Federal, State, and ACT High Courts are treated together, and finally the lower courts. Let's begin with the Supreme Court. Established by Section 230 of the 1999 Constitution as amended, constituted by its head the Chief Justice of Nigeria and such number of justices as may be prescribed by an Act of the National Assembly, this is Nigeria's highest court and has been so since 1963, when Nigeria made a clean break from the British judicial system. Until its establishment, the highest court in Nigeria was the Federal Supreme Court. The now abolished Federal Supreme Court was not a final arbiter, since appeals from it went to the Judicial Committee of the Privy Council. Our next court is the Court of Appeal. Established by Section 237, subsection 1 of the 1999 Constitution as amended, initially by the Court of Appeal Decree Now Act No. 43 of 1976 and the Constitution Amendment Decree Now Act No. 42 of 1976. It is constituted by its head, the President of the Court of Appeal, and a number of other justices, not less than 49, provided that not less than 3 shall be learned in Islamic personal law, and not less than 3 shall be learned in customary law. This is the second highest court of the land, and also serves as an intermediate court between the Supreme Court on the one hand and the High Court on the other hand. The next set of courts is the Federal, State, and FCT High Courts. The reason for considering these courts together is that they have equivalent powers and ranking. The Federal High Courts was established by Section 249 of the 1999 Constitution as amended. It is formerly known as the Federal Revenue Court, which was established in 1973. They renamed the Federal High Court in the 1999 Constitution. The State High Court is established by Section 270, subsection 1 of the 1999 Constitution as amended. This and the various High Court laws of those states control its operation. The High Court of the ACT is established by Section 255, subsection 1 of the 1999 Constitution as amended. By virtue of Section 252, subsection 1 of the 1999 Constitution as amended, the Federal High Court is basically equivalent to the High Court of the state. The Federal High Court is constituted by its head, the Chief Judge of the Federal High Court, plus such number of judges as the National Assembly prescribed in its enabling act from time to time. While state high courts are constituted by its head, a chief judge, plus such number of judges as the State House of Assembly may prescribe in its enabling law from time to time. The High Court of the FCT is constituted by its head, a chief judge, plus such number of judges as the National Assembly prescribes in its enabling law from time to time. Let's take a look at the lower courts. These include area courts, customary courts, magistrate courts, and Sharia courts. Magistrate courts are established by the magistrate court laws of their respective states, while area and Sharia courts were established by the Area Court Edict of 1967. In some northern states, these are known as Sharia courts. In other northern states, these are known as area courts. Customary courts are established by the respective state laws as well. With that, we are done with the first classification scheme, that is based on type, the name of the courts. We propose another classification scheme, and that is courts with original general criminal jurisdiction, courts with original special criminal jurisdiction, courts with appellate criminal jurisdiction, courts with worldwide criminal jurisdiction. Let's take them one by one. Courts with original general criminal jurisdiction. These are courts in which one can commence criminal proceedings at first instance. Courts empowered to hear all cases that are not specifically reserved for courts of special jurisdiction at first instance. Courts empowered to conduct trial into a case involving parties without discrimination or limitation and over a wide range of subject matters. These include magistrate courts in the north, magistrate courts in the south, high courts in the north, and high courts in the south. We also have courts with original special criminal jurisdiction. These are courts in which a particular class of individuals can be tried for criminal misdeeds at first instance. Courts in which a particular class of criminal omissions or commissions, actual or suspected, can be tried at first instance. Courts empowered to conduct a hearing of a case involving a controlled list of potential parties and or over a limited or specific range of subject matters. These include area or Sharia courts in the north, customary courts in the south, federal high court when trying criminal matters, juvenile courts which tries young persons, court-martial which try members of the forces, coroner's court which conducts inquests into the causes of death, and any other tribunals. Let's take one of the types, area courts and Sharia courts. By virtue of Section 24 of the Area Court Edict of 1967, it restricts area and Sharia courts from trying offences punishable by death. That's subject matter jurisdiction. The jurisdiction over offenders at the area and Sharia court is limited to any person whose parents were members of any tribes indigenous to some parts of Africa or their descendants, any person, any of whose parents was a member of a tribe indigenous to Africa, and a person who, while not falling among the two categories above, consents to be tried by the court. Subject matter jurisdiction is as conferred by warrant or by law. The juvenile court jurisdiction includes all young persons aged 14 and above but under 18, except the youth is charged jointly with an adult, in which case the juvenile court is robbed of its jurisdiction, or the youth is charged with culpable homicide. We'll now be moving on to the Federal High Court. Sections 251, subsection 1, 2, and 3 of the 1999 Constitution as amended lists the extent and limits of the subject matter jurisdiction of the Federal High Court. This legislation needs to be considered side by side with the following cases to grasp the extent and limits of the jurisdiction of the Federal High Court, as this is a favorite for examiners. Abbas vs. Commissioner of Police is a 1988 case. Alhaji Mandara vs. Attorney General of the Federation, 1984 case. Running Motors Limited vs. Wema Bank PLC, and a 1983 case. Eze vs. the Federal Republic of Nigeria, a 1987 case. Savannah Bank vs. Pan Atlantic Shipping and Transport Agencies Limited, which is a 1987 case. We are now done with the Federal High Court. We will now be considering court-martials. This court is endowed with two types of jurisdiction. Subject matter jurisdiction is as provided for in sections 45 to 103 of the Armed Forces Act and broadly includes military and civil offenses. Offender jurisdiction is as provided for in section 130 of the Armed Forces Act. By offender jurisdiction is meant persons subject to service law, but see also Olatunji vs. the State, a 2003 case. This is another examiner favorite. And the sort of questions to expect include the types of court-martial, the composition of the various types, the roles of each official in the various court-martials, the rules governing procedure, who can be appointed a member, who can head and who cannot head a court-martial, the quorum that needs to be formed, conditions to be met before an officer can be tried, who can convene the two types of court-martial, whether the power to convene can be delegated, who is subject to its jurisdiction and who is not, when can it impose the death sentence, the difference between the two types of court-martial, triable offenses, can an ordinary court try a case already tried by a court-martial, and vice versa? On the screen you can see a picture of the Federal High Court. Another picture of a court-martial. Now let us move on to the next classification subtype, courts with appellate criminal jurisdiction. These are courts which can hear criminal cases on appeal, courts empowered to hear criminal cases following or after their determination by either a court with original general criminal jurisdiction or a court with original special criminal jurisdiction or both. Courts empowered to review a trial court's proceedings for error. These include high courts in the north and high courts in the south, the high courts of the FCT, the Court of Appeal, and the Supreme Court. High courts in the north. These exercise appellate jurisdiction with respect to all appeals from magistrate courts and upper area or Sharia courts. It's see Section 272 sub 2 of the 1999 Constitution as amended, but subject to Section 251 of the 1999 Constitution as amended. High courts in the south, which exercise appellate jurisdiction with respect to all appeals from magistrate courts. See Section 272 sub 2 of the 1999 Constitution as amended, which is subject to Section 251 of the 1999 Constitution as amended. High Court of the FCT. This exercises appellate jurisdiction with respect to all appeals from magistrate courts. See Section 257 subsection 2 of the 1999 Constitution as amended, but subject to Section 251 of the 1999 Constitution as amended. We also have the Court of Appeal, which has no original criminal jurisdiction, but only appellate criminal jurisdiction with respect to decisions of the following: the Federal High Court, the FCT High Court, State High Courts, court-martials, any other tribunals established by the National Assembly. Please see Section 240 of the 1999 Constitution as amended. We also have the Supreme Court, which has no original criminal jurisdiction, but only appellate criminal jurisdiction with respect to the decisions of the Court of Appeal. The only limitation being the powers of the President in the case of the Federation, or the Governor in the case of a state, to grant prerogative of mercy as contained in Section 235 of the 1999 Constitution as amended, and Section 233 of the 1999 Constitution as amended. On the screen is a picture of the Court of Appeal, which we have just considered has appellate criminal jurisdiction. This is followed by a picture of the Supreme Court, which we have also discussed has appellate criminal jurisdiction in respect of decisions of the Court of Appeal. Our last type of court is the International Criminal Court. This court has jurisdiction over individuals and not states. It tries to hold such persons accountable for the most serious crimes of concern to the international community as a whole, namely the crime of genocide, war crimes, crimes against humanity, and the crime of aggression. This is the end of the third part of this course. We have now begun the concluding part of the course. Key concepts to bear in mind. We will treat three subtopics, just as are shown on the screen. Sitting, setting, and comparing sitting and setting. Sitting of a court. According to Black's Law Dictionary Free Online Legal Edition, the sitting of a court is the holding of a court with full form and before all the judges. The holding of a court of nisi priors by one or more of the judges of a superior court. Plainly speaking, the sitting of a court refers to what days the court can validly conduct proceedings, also called juridical days. Mondays to Fridays are juridical days, although Saturday could, under certain conditions, be a juridical day. Sundays and public holidays are non-juridical days. See Section 40 of the Magistrate Courts Law of Lagos State and Section 52 of the High Court Law of Lagos State. Exceptions to the general rule of the court sitting on juridical days include 1. If the parties consent, and the authority for those is Ososami versus Commissioner of Police is a 1952 case. 2. If there is a statutory backing for sitting on a non-juridical day, see Falaye versus Obasanjo. 3. If a case were inadvertently adjourned to a public holiday, Falaye versus Obasanjo. And 4. If the court needs to sit to hear matters of remand, bail, non-custodial dispositions. However, this is limited to Saturdays. See Section 40, Subsection 2 of the Magistrate Courts Law of Lagos State. Here are a few other points to take note of. The effect of a court sitting on a non-juridical day is that the proceedings are rendered a nullity, and the authority for this is also Sani versus the Commissioner of Police, the 1952 case we have earlier discussed. 2. The effect of a statute prescribing a time frame for disposing of a criminal trial is that such a statutory provision is unconstitutional. AG Ondo State versus AG of the Federation, that's a 2002 case. In Nigeria, a court starts sitting at 9 a.m. and stops sitting at 4 p.m. or in the alternative whenever the court rises for that period. We are now done with sitting of a court for proceedings. We will now switch on to setting of a court. So what is the setting of a court? The setting of a court refers to the physical layout of the courtroom and is composed of the following: the bench, which is where the judge or magistrate sits; the registrar's desk, which is where the registrar or other court clerks sit; the bar, which is where lawyers are permitted to sit. In the Supreme Court and Court of Appeal and High Courts, Such lawyers must be mandatorily be robed. In the Magistrate Court, robing is discretionary. See Rule 45 of the Rules of Professional Conduct. Two kinds of bar exist: the inner bar and the outer bar. The inner bar is for Attorney General, live benchers, members of the body of benchers and sons. The outer bar is for all other lawyers. If the design of the court does not accommodate an inner or outer bar, then the first rule will substitute as the inner bar. We also have the dock, which is where the accused stands or sits during trial. While in the dock, the accused can only make non-evidential statements since he cannot be cross-examined on the same while in the dock. It is situated to the left of the judge. We also have the witness box, which is where witnesses stand to give evidence. Please see also sections 205 and 208 of the Evidence Act. It is situated to the right of the judge. For an accused to make evidential statements and be subject to being cross-examined on the same, he must be within the witness box. Finally, we have a gallery, which is where those interested in but not participating in court proceedings stay to observe the same. Sitting and setting compared. Sitting refers to the days that the court can validly conduct proceedings, while setting refers to the physical layout of the court room. The next 3 slides contain source material for the history of Nigerian substantive and procedural criminal legislation. This first one was by Alan Gledhill. The second one was written by H.F. Morris. And this third one was written by H.F. Morris also. The rest are picture credits for the other pictures in this lecture: the Federal High Court, the Court of Appeal, the Supreme Court, the International Criminal Court, the setting of a court. Thank you for listening to this lesson.